Court of Appeals for the State of Arizona Division 2 is now in session.
Good afternoon. Please be seated. This is the time set for oral argument in Devine and Boston versus Randolph. Our case number is 2CA-CV 2012-0069. Counsel, may we have introductions, please?
Yes, Judge Bill Risner for the appellant.
Thank you.
Dennis McLaughlin with the City Attorney for Defendant-Appellee Roger Randolph, who's present in court.
Kim Demarchi for the intervener defendants, the campus acquisitions entities.
Counsel, thank you all. Counsel, we have read the briefs. We reviewed the entire trial court record, including the transcripts that have been filed with the court. So we are very familiar with the factual background. You may not want to spend a great deal of time with a dissertation of the facts, except what supports your argument. But with that, I think we're ready to proceed. Mr. Risner?
Thank you, Your Honor, and may it please the court, opposing counsel. I reserved about 10 minutes for a rebuttal, especially in this case where we didn't have responsive briefs, so I'm going to spend a bit of time responding to arguments they raised. Initially, I'd like to spend a little time kind of setting the stage by looking at the constitutional provisions and the truly unique situation that we have with referendums, initiative, and recall in Arizona. As you know, I think Whitman versus Moore talked about how it was a notorious fact that the Constitutional Convention, that the central issue in the selection of delegates related to these three issues, and the approval of the Constitution itself. And this morning I pulled out in reviewing the Constitution, and I was interested in seeing that right at the front of it, before it talks about having a Senate and a House and the members and so forth, it talked about the key issue, which was that in Arizona, the people didn't give the entire package of their powers or their legislative authority to the legislature. They truly reserved to themselves the powers of referendum and initiative and recall. And then they at the end had a self-executing provision. And I'm not certain of this, but I was reading a book about the Arizona Constitution that said that there were like 3 sections that were self-executing, and 2 of those were put in 1980-85. So this could well be the only self-executing. And then following up that, they actually had a section for penalty where the legislature was required to provide a penalty for any willful violations of any proceedings relating to referendum initiatives and recall. So truly, we are talking about a fundamental legislative power retained by the people. And in the Constitution, additionally, provided that cities would have the referendum powers, and then provided for charter cities to be able to have this in their charter. And Tucson put the referendum, of course, and initiative and recall as part of our charter. I pointed out, and I think it's clear that the testimony is that the rejected petitions by the city clerk complied with the state constitution, complied with Tucson City Charter and complied with Tucson's code. What the clerk has said.
Before you leave that,
Yeah.
let's stick with the Constitution. And I think it's undisputed that the powers of initiative, referendum, and recall are critical, and it's reserved to the citizens of the state of Arizona. That's undisputed, has to be. But what does the Constitution tell us about? You referred to the powers that cities have also under the Constitution. But what does the Constitution tell us about whether the legislature or the Constitutional Convention, whether they have decided to allow the separate counties or for that matter, the municipalities to come up with their own procedures for referendum in particular?
Well, they have said that the cities and counties can come up with their own within the context of the Constitution and general laws. And the key cases of recently the City of Tucson versus State of that April 6th opinion, Tucson Consumers for Retail Choice and Strode say that what that means is that essentially within this area and with the cities, the charter cities at least, can create their own provisions and standards for how referendum will work within their cities.
Just generally speaking, or are there set circumstances under which they can do that?
They can do that when it's an issue that is a municipal or local issue. That is, I think, the key cutoff. The state retains certain powers if it's an issue of statewide importance. So I think what it comes down to is it an issue basically of local municipal affairs, and within that area, in the charter and in the code interpreting the charter or effectuating the charter, the city can do what they want.
It seems to be central to your argument that you would like the court to focus on the ordinance itself and to support the argument that that specifically is a matter of local concern and not focus so much on the referendum process generally. Is that a fair characterization of your argument?
Yes, in the sense that the referendum process generally, the state has a role where there's, if there's also a strong state issue involved, then what I think the courts would try to do is to see if they can harmonize these kind of situations. But here, this is the organic law of Tucson. That is our system, and our charter creates that organic law, and this referendum is on a city ordinance that is of local interest. How there's development, in what manner it'll be in the main gate area of the University of Arizona is clearly an issue. It's a local issue.
Mr. Risner, not to rush you in any way, but let's assume that that's the case.
Yeah.
And that seems like a very sensible reading of everything you've laid out so far.
Yeah.
Get me where you're going in terms of how is it that the city's requirement does not extend to, I believe, Section 19 is the operative one here of the state statute. How has the city not incorporated that on its own independently without any compulsion, let's assume, or having to comply with Arizona state law, since this is a matter of local concern?
Well, but there's no place where, well, there's no place where the city's done that. We have a charter. It's not in the charter. We have ordinances. It's not in the ordinance. You look at charter section 20, 21, 19, none of that's in there.
That though seems to be putting the cart before the horse. Again, it seems central to your argument that the city never adopted Section 19101A
Right.
or the other provisions in Chapter 19, Title 19.
Yeah.
But is that required when, as a starting point, Article 4 of Arizona's Constitution indicates that cities may be able to set their own procedures for referendum as long as they don't differ or conflict with general law, which would mean state statute? Isn't that the starting point?
I'm not sure I'm following. The starting point is...
Why was it necessary? Well, the Constitution is the starting point. Can we agree with that?
Yes.
All right. And the Constitution expressly provides that cities and towns may be free to adopt their own procedures as long as they don't conflict with state law. Is that a fair statement?
Yes.
All right. So why then would it be necessary for the city to formally adopt state statute when it already applies?
Yeah, but they don't. The city has a charter, which it's permitted to do through the Constitution. The charter has rules for referendum. The city has ordinances that deal with referendum. And the problem you end up with is if you look at the city ordinances, it says, here's what the form should be. Here's the kind of what the form should be. Here's what needs to be in it. And here's what the standards are. So the city has a whole procedure. The state procedures conflict and throw our citizens who want to use the referendum process into the pit, because it's an entirely different system that the state has set up for what the form should be. You know, the state says that...
I need to ask a question right here, because I'm looking at the charter and the code.
Yeah.
And in Chapter 20, where referendum is addressed,
Yeah.
I think it says specifically the provisions of the next chapter, which is the one on recall,
Right.
Respecting the form shall apply to petitions of referendum petitions,
Right.
with modifications as the nature of the case may require, which is pretty vague.
Yeah.
And the only requirement in Chapter 21 for recall petitions focus on naming the officer in the office from which his or her removal is sought, the statement of the grounds for the removal, and that's it. So I'm trying to figure out how Chapter 20 lays out for us what a referendum is supposed to contain form-wise, when the only guidance we have is the reference to Chapter 21, which talks about the name of the officer and the office from which he's going to be removed. And please, I invite you to direct me to something more specific that tells in the code or charter what a referendum must contain.
Well, I think you look at, there's provisions of, there's ordinance sections that said also you look at initiatives. So you can see initiatives that say, you know, we, the undersigned,
Right, but I mean, as to the form, you're directed to Chapter 21. I'm looking at this, if I'm a citizen reading the charter and I'm saying, what am I supposed to put on this?
Yeah.
It says, well, look at Chapter 21. So I look at Chapter 21 and it says name the officer and the reason, unless, you know, the substance of a referendum is different, in which case you modify it, but it doesn't tell you how to modify it or what it should contain, unless there's some part of this I'm just not finding it in.
Well, I think you also, this section on, it refers you back to also initiatives, and it asks that you seek the help of the city clerk in setting up this form. But the forms that the city requires in our charter, because they were wanting to be helpful with referendums. They wanted it to be an easy process, because the key to the process is getting the required signatures within the time limit that meets the form that's within the Constitution. And since you need to attach the entire ordinance that, or part, whatever it is that you want to get the referendum for, then it's, the little form stuff isn't really the kind of critical aspect of it. That's why it can be somewhat looser. That's why if you look at, I think it's, isn't it number 3 in the Appendix 3B, the city has a petition for referendum that is quite simple. That's one of the petitions that form that they put there, and that's and then you'll see at the bottom where it says in 200 words or less. That ties back with provisions in the charter and code. So really, it's not a complex matter. The problem.
This is called the title and text page, though. Is that the same as the whole petition?
Well, yes, the city, and I think it's in the initiative and referendum rules, defines petition as being the title page, the signature page, and the explanation page. That's definitional as to what the petition is. And you know, if you look at the 19-101A, there's no way to win that one, because that one, instead of trying to help citizens use this important power, says that you need to like point out every important thing in your ordinance that you want reviewed within 100 words or less. So you end up with the kind of argument like the interveners are making of when the citizens say that you can have 17 buildings up to 14 stories. Oh, well, that means that you're out of here because you didn't explain that 4 of them are 14 and 3 are 13 and a couple of 12s and so forth. Because there's really no way that you could comply without being challenged every single time on a long ordinance.
Well, why wouldn't accuracy be important then? I mean, can't you say in the same number of words that we're talking about 4 buildings of 17 stories, or as opposed to 17 buildings at whatever it was? I mean, it's...
You could talk about that in those words, but this is at least a 25-page ordinance. And do you think in 100 words you can go through a 25-page ordinance, explain everything that's important in that ordinance, and then not have someone come in and challenge and say, well, on page 18 there's something that's really critical on this thing, and on page 6 there's something that's really critical, and on page 9 there's something else that's really important. It's a long, complex ordinance that you have to have all of it there. And what 101A does is really put citizens in a deal where they'll be challenged every time, and it's heads we win, tails you lose. I mean, it's really a very difficult situation.
Yeah, that's a statute that applies. Maybe not according to your argument in this context,
right? But
that's the statute that applies nevertheless. And I'm not aware of any court that has held that 19-101A is unconstitutional. Are you?
No, but that's not the statute that applies in the city of Tucson pursuant to its charter for a matter of municipal interest. That's why our citizens, when they set up the charter in 1929, did it within the context of they were in favor of referendums, and they wanted it to be a process that could be utilized by the citizens.
All of the cases that I've read, and let's just stick with the Supreme Court cases, they address charter cities. They address both the initiative and the referendum process, and it seems to me that the court is not focused on the particular ordinance itself. They're concerned in all of the cases that I've read, they're concerned with the referendum process generally and whether that was complied with under the statute. So none of these cases view the matter of local concern in the same way that you're arguing to this court.
Well, I don't think any of them have made the arguments and have focused on the charter. That's why you need to look, and I think the critical case here is the City of Tucson versus State of Arizona case that came down just last month. It absolutely talks about the issues of how state law statutes apply, and the state statutes don't apply when it's an issue in a charter city of a local issue. They apply to the 71 other towns in Arizona, but if it's a local issue and there's a charter on it, it doesn't apply. That's what the City of Tucson.
You know, let me jump in there, because that just goes back to the question I asked you a while back. Let's assume that's the case.
Yeah.
Okay? Let's just assume that we would accept that position.
Yeah.
Then tell me again why the city has not basically adopted the state law requirement of 19-101. The city gives people a form, I think, a sample form that has the notice requirement and the voter requirement
Okay.
on it.
Look,
But just explain to me, because
Sure.
I mean, maybe you're right, I'm just not quite following you.
the mayor and council has never adopted it. It's not in the charter. It's nowhere in any city law. It's nowhere in the rules and regulations book. And this rules and regulations book doesn't even have the recall sections of the charter, which, you know, as Your Honor mentioned, is what they say apply. They aren't in here. The rules and regulations book that's here isn't even voted on by the city council to say we accept this thing. So it has rules in that the city clerk has just put in.
Aren't there provisions, though, that say that the city, I guess through its administrative personnel, like the city clerk, can adopt certain regulations and agree on ways to do things as far as form and procedure?
Absolutely, they can if they're authorized. If they're authorized by statute or the Constitution. But they can't adopt rules and regulations that are contrary to the charter, that are contrary to the city ordinances. And here, it's not even an issue of could they adopt them. They don't even adopt them. I've looked in here, and I've not seen 19-101A anywhere. And if you look at, as I mentioned, the sample on the appendix, what they've said is that, look, because an appendix 3B2 uses the same language that you could discover if you really search hard in the state statute in 101, you could find that language. Because it's used in the fine print, that means they've adopted 19-101. But look at appendix 3B, which is the petition for referendum, that doesn't have that language in it, but does comply with the charter and with the ordinance. The city clerk is just simply not authorized on his own to say, I'm going to adopt all the requirements of section 19. He can't do it. And the mayor and council haven't done it. No one's done it. And the whole key to what Judge Gordon said was because on the back of this rule book, in the fine print, there's language that mirrors a state statute that's number isn't cited. That means the city's adopted it. That can't be. That goes against all our administrative law. I don't know if I've eaten up all my time or not.
I think you're out.
Yeah. Thank you.
Thank you, Your Honor. The plan, if we can do it, is that I will speak for 15 minutes, and Mr. Demarchi will speak for 10 minutes. More or less. I want to take something a little out of order, and that is go right to Judge Espinosa's question about incorporation, we'll call it incorporation of the statutes by the city. And Mr. Risner, Gerard's argument was claiming that we hadn't done that, and nowhere did we. And in fact, we have done that. Chapter 20, Section 3 authorizes mayor and council to pass ordinances to further the procedure. Tucson Code Chapter 12, Section 12-1.3 says that the clerk can have regulations. The clerk Clerk's Regulations, Section 1.2, Exhibit H and Exhibit A in the trial. Provisions governing the initiative and referendum processes are set forth in the Tucson City Charter and supplemented by the Tucson City Code. Provisions contained in these rules and regulations and applicable provisions of the Arizona Constitution and the Arizona Revised Statutes, ARS. Now, to the extent there's any question about applicable, 19141 says that the provisions of Title 19 are going to apply in cities, towns, and counties, except as specifically stated to the contrary in that chapter. So we've incorporated this. But alternatively, my first argument, which I'll now present as my second, is that in addition to incorporating it, it's also mandated. Your Honor had talked about the Constitutional Convention. And the initial provisions for referendum in the Constitutional Convention would have said localities will control the methodology, the procedure for governing this. Those were rejected as far as a constitutional matter. What they picked was what we know as Article 4, Part 1, Section 1, Paragraph 8, which I'll just shorthand as Paragraph 8. And Paragraph 8 says, municipalities can have procedures within the restrictions of general laws. And it's not as simple as saying, well, the legislature will always be restrictive and be very narrow, because if you look at the history up to 1991, the legislature wasn't strict. Some of the early provisions, and I had them in my appendix, would have basically, it was the world as the initial provisions might have had it. That if there's anything that the localities pass that conflicts, that's going to control. But that's not the world we're in anymore. In 1991, they enacted 19141A, the current version, that says all state statutes regarding referendum apply to local referendum, cities, towns, and counties. So you've got a mandated 19101A with its provisions, and you've got an incorporated 19101A, and you can pick whichever you want. I maintain it's mandated, but it's also incorporated. So they both apply. Now let's look at 13.2, the general charter provision in the Constitution. That, Mr. Risner has said that we never adopted 19101A. The fact is, under 13.2, 19101A, like any state law, applies to charter cities as anywhere else in Arizona, unless there's a conflict. And if there's a conflict, then the charter will control to the extent the matter is strictly a matter of local concern. There is no conflict here. Just as in the Walmart case.
Before you move off that.
Sure.
The city zoning ordinance, Mr. Risner argues that that seems to be a matter of local concern. And I can't dispute that a local ordinance seems to be a matter of local concern. Why doesn't that trump then the statute?
Sure, two things. First of all, as I think one of you pointed out, and if you didn't, I'll point it out, it's not about the particular ordinance necessarily, it's about the referendum process. And the referendum process, as this court assumed but didn't decide in Walmart, is both a matter of local and statewide concern. Moreover, this is a zoning matter. The city's zoning power comes out of state law. We do not have power over zoning except as the state grants it to us. So when he says, well, this ordinance is just a matter of local concern, it's not a matter of local concern as to the referendum process, and it's not a matter of local concern as to the zoning process. So for both of those reasons, you can have both statutes and local provisions that are going to apply.
Let me change the dialogue just slightly.
Sure.
That's also a strong argument, and let's jump over that for a moment. Why don't we have substantial compliance here?
There's a number of reasons. Why don't we have a standard, or why wasn't there substantial compliance?
Why cannot the facts of this case, a lot of efforts to do what people thought was required, and they're out gathering signatures which haven't even been verified yet because this all got stopped early on. Why don't those efforts amount to substantial compliance?
First of all, there's the standard that applies to referendum, which is a well-settled standard that says, no, it's not substantial compliance, it's strict compliance, because unlike an initiative where you're doing an initial legislation, in referendum, you're holding up a law that's been enacted by an authorized governing body. And when you do that, according to the Arizona Supreme Court, you have to comply strictly with the statutory and constitutional provisions and any local provisions that might apply. Now, we also don't have...
Well, let me back you up for just a moment.
Sure.
In the Wilhelm case,
yes,
that's been cited, that seemed to relax the standard for substantial compliance to some extent, if not significantly. And why doesn't that cover our situation here?
Initiative case, and I actually cited Wilhelm, so if you got me, you got me, but I don't think you did. It was an initiative case, and substantial compliance was found in a case where there was a description that had left out the statute of repose. It didn't really mention the statute of repose, which was apparently a key provision in that initiative. There was a description, a notice to voters, the same one that's missing here, and the court said, you know, that notice to voters warns voters that they need to read the whole provision, that they shouldn't simply rely on the description. On those facts, we're going to find substantial compliance. Now here we have a case where the trial court said, I'm going to get the quote wrong, but it's potentially misleading, it is inaccurate, there are things in there that are not correct, and we have no notice to the voters.
But isn't a voter reading this thing going to pretty much see what it's about, get the essential elements of what is being proposed in these petitions? Just like in Wilhelm, okay, they left out a pretty important detail, which was the statute of limitations. And our Supreme Court said people would still understand what this thing was about, and they would still, have enough of an understanding to exercise their franchise.
Except that the legislature wants them told that they can do that. They want them specifically told that in the petition in writing, and that didn't happen here. So you don't have the petitioners telling the voter, the signer or voter, potential voter, the same things that the legislature said you need to have in there so you have a knowledgeable voter signing that petition. So I don't think there's any way there's substantial compliance on that basis.
Well, we're talking about substantial compliance. I think it's the last sentence in paragraph 21 says that for recall petitions, substantial compliance is sufficient.
Essentially, it says no defect will devoid the petition. It's like a no compliance standard, and it's that provision relates to recall because it's unique to the city. It's in the charter, not in the statutes. On a recall petition, Mr. Randolph, the city clerk, is going to actually provide you with those petitions, unlike referendum, where the petitioners are going to print their own. And the concept there was, if the clerk is going to give you the petition, the clerk can't later come back and say, well, look, there's a defect in this petition. I'm not going to allow that.
Well, that's sort of similar to Mr. Risner's argument that the sample is handed out to the person who wants to initiate a referendum, the sample of petition, and if petitioners turn something in that complies with that sample, then
Except that the
defect in form,
Sure.
since Chapter 20 says Chapter 21 governs as to form, why shouldn't that be enough?
The 20 Section 1 refers to form, and 21 Section 3 talks about form, the number of signatures, the fact that you can have more than one petition. The title of 3 of the form section in 3 is separate from where that is. So that's one problem with relying on that. Another problem is basically I don't see where under the Constitution we are allowed to develop a separate standard locally for referendum that is different from what the Arizona Supreme Court has said applies statewide. The standard of strict compliance that they have should be applicable to all localities under paragraph 8. We'll just say under paragraph 8.
And which Supreme Court case said that?
Well, there's a number of them. The Cottonwood case says it. The Western Deaf Corps says strict compliance. Where they apply a strict compliance standard in referenda, and they do it. I'm trying to think of if there's one that immediately comes to mind that's localities, but I think at least one of those. Western Deaf Corps, I think, was City of Scottsdale, and it involved a local referendum by a charter city, and they said strict compliance. So the idea that you're going to take 21(2) and say, well, 20 Section 1 adopts 20 Section 2 of the charter, I think is a stretch, both for as a matter of law and because those provisions, as an early question of yours indicated, there needs to be a change based on the facts, because the 20 Section 1 says we're going to adopt this with such changes as are required, which is a vague standard. I agree with you a little bit, but it certainly covers the idea that if you have a referendum, you're going to be back to the constitutional normal standard of strict compliance.
One other question. One of the arguments that Mr. Risner raised, gosh, I've lost my train of thought. Let's go on to someone else and I'll come back.
I want to make one point on, Mr. Risner was talking about the description. He had a interchange with you about the description and the fact that there was only 100 words and how difficult this was. That's why the notice is so important, because the description is only 100 words. And if he can't have it both ways. He can't say, well, it's too tough to get it in 100 words, but I get to leave out a notice that tells the voters, go read the whole provision, because it's a long provision.
Now, wasn't the provision attached to the petition?
The ordinance was attached, yes.
Okay, and aren't people aware of that? And weren't the circulators perhaps mentioning that to them?
I don't know if it was in front or in back. Truly, I can't remember if that's in the record, and I don't remember. But if it was in back, there's no way, unless they're told, that they would necessarily know to read it.
But don't you think most people at least flip through it? I mean, I do. If I get one of these things, I want to see what it is, and it's all there.
You may or you may not, but the legislature thinks that you should be told that you have a right to do that. That this may not be the whole thing. You have a right to read it, make sure it's attached, and read it. And that wasn't there. So we're back to the strict compliance.
While we're on the subject of the description, 19101A provides for a description of no more than 100 words
right.
in describing the challenged ordinance. Whereas, as I recall, the city ordinance indicates that it can be as high as 200 words.
The sample says 200.
And that appears to be a conflict. How do we reconcile those?
It's not an issue here. I think it's a misprint. It's not the basis where the clerk rejected the petition, and I grant you it said 200 words. But I think to the extent it's 200 versus 100, you come back to paragraph 8 in 19141, within the restrictions of general laws, and the general law 100 words is going to apply.
What about the...
Go ahead, I just want to finish my question before we run out of time, now that I've remembered what it was. Mr. Risner had argued that in his brief that even if the petitions weren't, didn't follow the form, that there was excusable neglect by the clerk, and that should basically permit the petitions to be filed. And since, as he's pointed out to several times, the sample that was given to, I think it was Miss, was it Little?
Little, yes. Mm-hmm.
When she first came in, didn't include those things. Why, I mean, would you respond to that argument before you had it to?
Sure, absolutely. Two things. First of all, there's no causal connection. We gave them a sample. Actually, you can make it three things or two things. We gave them a sample that had everything that should have been in there. That's Appendix 3B2. They asked for an electronic version for formatting, which was never intended to be a textual template for them. It was going to give them margins, fonts. That had 2 sentences of the notice to voters missing. Now, when they give us the petition, they don't give us a petition that looks anything like our samples in terms of the violations. It doesn't have any of this language. And so you don't have a causal connection. That's what the trial court found, and we think that that's entitled to deference. Secondly, there's clear precedent at both Supreme Court level, Court of Appeals level, this court, in fact, that it doesn't matter what the clerk said. You are responsible as the petitioner for the proper form of a referendum petition, for strictly complying with the Constitution, statutes, and any other requirements.
You know, you said there was no causal connection, but wouldn't the electronic form be the form that people would actually use? Because nowadays we do everything on PCs, and you know, you can generate your own form from that form.
Yes.
And wouldn't people kind of have a right to rely on that form, since that's the one they're most likely to use?
I'm not sure that it's in the record described exactly this way, but I definitely see your point. The problem here is that I think it was asked for just what I said. It was a formatting. We want to know margins and things, and then we're going to drop our own text in there. Now, and so.
Was there evidence of that at the hearing?
I don't remember. I don't remember if it went into that much detail. But also, we've given them a sample, and we've given them Title 19, and we come back to the idea of we may well have made mistakes, but the trial court found we weren't trying to intentionally mislead them. As Mr. Risner says, we were trying to help them, and they didn't look at what the law says they should look at.
And what body does the authority for the clerk to reject petitions, just initially without any counting or any challenge to them? From what does that arise?
19122, I believe, is the 19122A.
Before you sit down,
Yeah.
This is your ordinance, so I want you to address it. At what point do we ever reach a point where, I understand that we've got a statute, and we have the Constitution that pretty clearly says that the statute controls in the event of a conflict, unless we're talking about a matter of local concern. At what point, though, do we reach the point where the involvement of the city, the involvement of the city clerk, the city's own ordinances, when we're talking about pursuing a referendum about a city ordinance, do we ever reach the point where that becomes just so much, for lack of a better term, a bait and switch, that it's just so difficult to understand which direction you have to go, and the court has to step in and grant relief? And before you answer that, I want to point something out. In Chapter 20, that deals with referendum,
Yes.
It specifically refers back to Chapter 21, which has to do with recall. And it says that those provisions in Chapter 21 with respect to form, filing, certification, rejection, and action on recall petitions is going to apply. So, in summary, Chapter 20 refers to all of those provisions in Chapter 21 that it's kind of bringing into Chapter 20, correct?
Yes, but not including 21-2, according to my position.
My problem is, then we go to Article 5, which also has to do with referendum.
Yes.
And then within that, in Section 12-76, it doesn't refer to recall anymore. Now it refers to the provisions relative to initiative are applicable to the referendum. And again, it provides very detailed, well, by scope of reference.
Yes.
It provides very detailed provisions, again, that's tied to the initiative petitions.
Tracking the titles.
How is anybody supposed to reconcile that?
Well, in terms of the requirements that issued here, they should read Title 19. They should use our sample petition, which they didn't. Our sample doesn't show up. And going to your question of at what point do we reach, if we had a petition that came in where it's a totally defective petition that was our sample petition and that's what they used, we'd have a hard time. But that's not what happened here. Wherever that point is, we haven't reached it because they haven't complied at all with even what we gave them in the sample, which was correct under 19101. And it is difficult, but they need to seek legal advice. They need to look carefully. They need to consult with us, and they need to maybe not try to do this in 36 hours.
Well, they did consult with you, didn't they?
Yes, they did, and we were doing our best to tell them. And I guess in one sense, no good deed will go unpunished because we're trying to help them, and we have things that are problematic, and then when they don't use what we gave them, then they come and complain about it. Or actually the petitioners aren't complaining, 2 other people are complaining.
Did anyone tell Ms. Little that, look, these 2 things, first page, these are really important. You've got to have these.
In the email that was the cover email for the electronic version, we told them basically, this does not, no, you are responsible for proper form of this petition. We always say that, and we're telling you right now. And then in the regulations 1-2, it says, these regulations aren't a substitute for legal advice. You need to go get legal advice about your specific issues. So, I will yield.
Ms. Demarchi, you have about 1:45.
So let me start with the most important factual finding, which is entitled to deference. Even assuming that petitioners who receive a paper form and an electronic form are more likely to start with the electronic form. The electronic form had 3 of the 5 sentences of the notice and the entire voter statement. The petitioners did not use either of the forms with which they were provided. And so if you accept Mr. Risner's version of the law, which requires you to find a conflict the city doesn't see in its own charter, requires you to find that a matter the state constitution commits to the state legislature is actually a matter of exclusively local concern. If you're willing to do all of those things, at the end of the day, what the city charter and the city code say is, use the form the clerk gave you. And if the clerk messed up in preparing the form, that's really what Chapter 21 says. If there's a defect in the form the clerk provided you, we're not going to hold that against you, so long as you use their form. The reality is, they didn't use either of the versions of the form they were given. And in doing so, I'm not even going to talk about 19101 in strict compliance. It's well established that the standard for 19101 is strict compliance. They don't even try to argue they strictly comply. But talking about substantial compliance, they've left out the constitutionally required language that says, I'm a voter in Tucson, I'm an elector, and this is what I'm doing. And they left out the provision that's supposed to protect them against misrepresentations regarding the description of the ordinance, and capped that off by misrepresenting the nature of the ordinance. This isn't going to comply with substantial compliance.
Let me stop you just for a moment. Are you saying that those provisions were present in the electronic form?
Yes. The only thing that's missing from the electronic form, the notice provision has introductory language and then 4 lines. 2 of those lines are missing in the electronic form. The introductory piece and the other 2 lines are actually there. If you look at it, it's Trial Exhibit 1, it's contained in the appendix. It also has the entire voter statement. What probably happened is that when they went into the electronic form, they just, instead of inserting, they overwrote those provisions. But they were there in the form they were given. So this whole discussion about how difficult a process this is and the right of referendum, we have all of these measures designed to help folks get through the process, like a sample form. And what you have here are folks who didn't use the sample form. At the end of the day, this case comes down in many ways to that factual.
What's that exhibit number again?
It's exhibit number 1 in the trial court, and I can give you the reference from my appendix. It is in our appendix at page 6. And this is what Mr. McLaughlin was calling the electronic version that was provided for formatting purposes. And it does contain most of the notice provision and all of the voter stuff. I've exceeded my time. I appreciate your forbearance.
Mr. Risner?
Yeah.
So you've got 3 minutes.
Huh?
3 minutes.
Oh, thank you, sir. Couple things. One, I want to point out again that Appendix 3B, neither the City of the Interveners have provided that. That's an important one. It's a referendum form that's also in the appendix. It's quite different from 3B2. And
Do you disagree with what was just stated, that the electronic sample form that was provided to us actually did have this language, which seems to be one of the big problems here, the notice and the voter statement?
It does have part of that. It's not complete. They would have rejected that one had it been submitted. But the real key to all of this stuff is that this 19101 has absolutely not been adopted by the city. The argument that says that because 19142 says it applies to the city, that has been shot down in 3 separate cases. It's you look at Strode, you look at the City of Tucson case of April 6th, and then that City of Tucson case on April 6th, that was a situation where the legislature said, we make a specific finding that this thing is of statewide importance and absolutely applies to all cities. And they said, no. Tucson is a charter city. They can pick their own government, and they have in the charter a different way of doing things, and this simply doesn't apply because it's a local matter of a local election. And and here there is not even that where it says.
Well, let me stop you there. Mr. McLaughlin walked us through the various city provisions that seem to link us up to Section 19101. Tell me where that falls apart. Well, you were tracking, because we asked him that, and he said, yes, the city has adopted Section 19101. So you're saying that's not the case?
Absolutely not the case.
Okay, tell us why.
Well, I don't really recall where you said they had. What Judge Gordon said, and what I believe the argument is that because if you looked at Appendix 3B2, that form, and you followed that language, it would say that matches with the state statute. Nowhere in here, nowhere does it say the City of Tucson has adopted 19101A, and we have a charter. We have an ordinance. The charter and ordinance can only be changed by the people of Tucson to change the charter, or the city council to pass an ordinance. They've not done it. The city clerk, he pointed a section where the city clerk has the ability to make some rules to effectuate the election change and to make some rules to effectuate Charter Section 19, 20, and 21. That's what he cited. One 2 says.
Well, let
that's the
me
clerk.
interrupt, and I'm sorry to keep interrupting,
Yeah.
but this may be important.
Yeah.
I believe Mr. McLaughlin said that the city has formally and properly adopted Tucson Code Chapter 12-1.2, if my notes are correct here, and they could be flaky. So the city, in those provisions, has incorporated Section 19-101.
Well, they did. So what he's saying is Section 12-1.3 says city clerk may promulgate rules, regulations, procedures, and forms necessary to conduct city elections and carry out provisions of this chapter and of the charter. That's his authority. The city clerk does not have authority to say, we're adopting all of Title 19. He doesn't have that authority. It doesn't say he does. And he didn't. Nowhere in here can you say, does he say, I've adopted 19, see 19-101. You're not going to find 19-101 anywhere. It simply isn't there. And so the way that Gordon did this, and why he's so wrong, he says, if you look at an appendix section and you look at the language, bingo, the city clerk has adopted all of this stuff and sucked in all of those sections, and he hasn't done it. And nowhere will you find a case in Arizona that I don't think that says that if there's a constitutional provision and you need to use this strict construction that the city of Tucson can't do otherwise. That's not really anywhere. And if you would grant me a moment, the issue of strict restructuring, where they have taken in some cases the referendum and making it different than recall and initiative. This was done first in the Cottonwood case, and what they did was they took some language from a 1916 Minnesota case, and that Minnesota case we would agree with absolutely, because what it said was when you have a time limit like our 30 days that you need to file something, you've got to do it on time. So most of the key cases in Arizona that deal with the strict stuff talk about when it's in the Constitution and those kind of things. So it's really kind of the I call it the Willie Coyote of the rules, where there's not much underneath it, but nowhere does it say that any charter or any city would be prohibited from having in their charter how they want to make the rules and apply those rules.
I just wanted, this is just for clarification, but your plaintiffs are elected as people who sign a petition?
Yes.
Are they also committee members, or were they just signers?
They're just signers. To be able to challenge these things, you just need to be a citizen, and they're one of the almost 12,000 people
We
who
just don't
signed.
want to refer to them incorrectly if so they're plaintiffs by virtue of having signed.
Exactly. Exactly.
Mr. President, thank you. Council, thank you all very much. We recognize that this is an expedited election appeal, and we will issue a decision as soon as we possibly can. We'll take the matter under advisement. Thank you.
Ms. Rise?